Hi, everyone, and thank you very much for joining us for today's presentation about the E-2 visa. My name is Dustin Saldarriaga, and I am a Senior Associate at Scott Legal PC. I will be joined for today's presentation by my colleague, Kelly LeGrand Weiner, who is a a partner at the firm. So a few housekeeping items before we get started. Our presentation is being recorded today, and you will be able to find a link to the recording on our YouTube channel. We will be sending you an email after this presentation that includes a link to our YouTube channel where you can find the recording, as well as a variety of other videos about the range of visa options that are available in the United States. And those videos are both full-length webinars as well as shorter videos on a variety of topics. That email that you'll receive will also have a copy of the PowerPoint presentation that you see on your screen, as well as a guide to the E-2 visa, which is really a comprehensive guide that includes the best information that we've gathered as we've helped clients navigate the process. If you have a question during today's presentation, please do send it in through either the chat function or the question and answer function on Zoom. We will be monitoring questions. It's likely that we will save questions for the end of the presentation, but don't hesitate to send those our way during the presentation. I do want to quickly add a couple additional notes. The first is that although our firm does focus on business immigration, we do handle the full spectrum of U.S. immigration law. So whether that is family-based green cards, temporary visas like student visas or visitor visas, as well as other issues like litigation against the government, if you have faced a denial or an extensive delay on your application. So we do hope that you'll reach out to us if you have any questions or issues regarding U.S. immigration law. And the other topic I want to quickly mention, which I think is very important, is that our approach to how we assist clients is very much informed by the fact that our founding partner, Ian Scott, has personally navigated a number of visas, including the F1 student visa, the H-1B, the TN, as well as the E-2, which we'll be talking about today. And our firm was actually founded on an E-2 visa. Ian remains in E-2 status, so his experience navigating these different visa pathways really does inform the way that we help our clients. We think that really does make a real difference in our approach. So today's presentation will focus on the E-2 visa, which really is, I would say, the most common visa that we help our clients navigate. And there's a very good reason for that, which is that as we'll discuss, the E-2 visa is established through treaties that the United States has established with other countries. And the idea behind those treaties is to make it easier for people to come to the United States to build businesses that create jobs for US workers. So let's go ahead and dive in by first talking about what the E-2 visa requirements are. As I mentioned, the E-2 visa is established through treaties. So treaties are established between the United States and dozens of other countries, and those countries are in Latin America, Africa, the Middle East, Asia, Canada, Mexico. So the first step to qualify for an E-2 visa is to have a passport from one of these E-2 treaty countries. To check whether your nationality, your country of nationality, is an E-2 treaty country, you can quickly go on Google and search E-2 treaty countries. You'll see a list of countries that's published by the U.S. Department of State. I think right now there are somewhere around 80 plus E-2 treaty countries. So there really are many E-2 treaty countries. But you do need to hold a passport from one of those countries. It is not necessary that you have been born in one of those countries. So for example, if you have a passport from Canada, but you were born in India, you do qualify for an E-2 visa based on your nationality because you hold a Canadian passport. Now, even though there are over 80 E-2 treaty countries, unfortunately, there are some quite populous countries that are not E-2 treaty countries. So for example, India, China, Brazil, South Africa. these are not E2 treaty countries. That doesn't mean you cannot apply for an E2 visa, but what it does mean is that you do need to hold a passport from another country that is a E2 treaty country. So what people will sometimes do is acquire citizenship through investment. Grenada does tend to be a popular country for this. And if you do hold, again, if you do hold a passport from an E2 treaty country, you do qualify based on the nationality requirement for an E2 visa. Now, there is a recent change which does require you to actually live in the country where you acquired that citizenship. So, for example, if you acquired citizenship in Grenada, you would actually have to live there for 3 years before you apply for the E2 visa. But it is important to know that it is a pathway available to individuals who do not currently hold a passport from an E2 treaty country. The second requirement for an E2 visa is that you need to own at least 50% of the E2 company. Now, what does this mean? So again, the E2 visa, E2 investor visa, is for individuals who want to develop and direct a business in the United States. So the first step usually to pursuing an E2 visa is to create a business in the USA, create a business entity. That can be a corporation, it can be a limited liability company, an LLC. It can be a sole proprietorship. It really can take any form. We tend to see and recommend either a C Corp or an LLC. But after you have established that, you do need to ensure that you own 50% of the company. So what that means is you can have two E2 investors based on a single company if each owns 50% of the company. But the moment that your ownership drops below 50%, you do lose E2 status or eligibility. So it's very, very important that you always make sure you own at least 50% of the E2 company. So for example, if you're planning to sell equity in your company, the E2 visa might be challenging because if you're selling equity, oftentimes your ownership share will drop below 50%. So do be careful there. But if you're not selling equity, and frankly, most of the businesses we see, which tend to be smaller, do not need to sell equity. So that 50% issue is usually not one that's a problem. Third, you must make a substantial investment into the E2 company. So what this means is you actually need to commit your personal funds to the US business. The US government looks at this as almost a kind of test to see how serious you are about your representation that you plan to develop and direct a business in the United States. A way to think about this is if a friend reaches out to you and says, "Hey, I'm thinking about moving to the US and starting a business." If you're trying to gauge how serious they are about this, if you ask them, well, have you taken any steps? Have you invested any money in the business? If they said no, I haven't invested anything, it's really just an idea at this point, you're going to be skeptical. Are they serious about this? In contrast, if they've transferred $100,000 into the business and actually spent that money on the business, you're going to think they're very serious about this commitment. And similarly, a consular officer is going to take a similar approach and is going to want to see that funds have actually been committed to the business. This is written into the law, though. It's not just a consular officer's perspective. So specifically, though, funds do need to be at risk. So it is not sufficient to transfer funds, say, to the business bank account in the United States and submit the application saying, well, the funds are sitting in the business bank account. That's not sufficient because the owner can typically transfer the funds right back out of the business bank account. So what the government does want to see is that the funds have actually been spent, that you've transferred your personal funds into the US company, and then you've actually spent them on the business. We'll talk about specific examples of good expenditures versus weak expenditures. Now, the source of those funds is extremely important and is usually the the bulk of what an E-2 application is going to show. It's going to be documents showing where those funds came from and the path that they took from their source into the US company. Fortunately, the government accepts quite a broad range of sources of funds. So the source of your funds could be the sale of personal property. Maybe you sold an apartment abroad. It can be inheritance. It can be insurance proceeds. It can be a gift from a family member. It can be a loan from a bank or a family member, a friend. So the variety of options really is broad. The thing to know, though, is that the source of funds does have to be lawful and legitimate, and you need to be able to prove that. So, for example, if your source of funds is Bitcoin, very difficult to document the source of those funds. So, we tend not to recommend Bitcoin proceeds as a source of funds. You do need to document where the funds came from. The other thing that's important to know is that they do need to be your personal funds. So we do recommend that the funds first arrive in your personal bank account before they are transferred to the E-2 company. The funds also cannot be retained earnings of the US business. So for example, if you already have a US business and it's doing well, it generates income, and that business has, say, $100,000 in retained earnings sitting in its account, you cannot say that those funds are your investment. You actually need to distribute those funds to yourself, pay taxes on them, reinvest them into the business, and then you can use them as your investment amount. The other thing, final thing that I'll mention about source of funds is that if you are taking a loan, the source of funds um, cannot be a loan that is secured by the US business. So you can take a personal loan that's secured by your personal assets, but the loan cannot be secured by the US company. Um, Sorry, one other quick note. If the source of funds is a gift, the person who's making the gift does need to document where they received the funds. So you can't get around the source of funds documentation requirement by taking a loan or a gift from someone. You do need to prove to the government that the funds were lawfully acquired. We'll talk about how much of an investment is enough. This is really the most common question we get, I would say, regarding E-2 visas. We'll talk about that more in the next slide. And we'll also talk more about what typical E-2 expenditures are. Real quickly, they really are expenditures that are necessary for the business to be operational, startup expenses necessary for the business to be operational. But we'll get into more details about what that includes. The next requirement is that the business cannot be marginal. Now, this is a term that we don't use every day in English, this marginal word. What this really means is that you need to convince the government that your business will employ US workers. If the consular officer is not convinced that your business is going to employ US workers, you are extremely likely to be denied. Conversely, if the consular officer is convinced that you will employ US workers, and even better, if you can show them you already employ US workers, then that can actually overcome other weaknesses in the case. And that's a big part of this presentation, which is looking at what we call risky or low investment E-2 applications. So one of the key things you want to do if you have a risky or a low investment E-2 application is to strengthen this hiring piece, to show the government, the US business is already employing US workers. Therefore, if it's a low investment amount, it's less relevant because you have clearly invested enough for the business to generate income and employ US workers. So hiring US workers is a key part of an E-2 application. What we would usually recommend is that within 5 years of starting the business, your US business employ at least 3 full-time equivalent US workers. That is a helpful benchmark. So you don't need to have employees before you apply. You also don't need to employ people in your first year, although it's great to do that. 3 full-time equivalent US workers within 5 years is really at a minimum, what you want to be able to show the government your business will accomplish. And you can do that through a business plan if you don't already have those employees. We can talk about that later. Next, the business must be real and operating. So that does not mean that the business is already generating revenue at the time you apply for the visa, although if you are, that's excellent. What it means is that the business is ready to start operations the moment your visa is granted to you. So if you're sitting in the interview with the consular officer and they ask you, okay, once I grant this visa, what else needs to happen for this business to be operational? What they want to hear in response is, I need to get on a flight and show up in the US. Once I show up in the US, this business is ready to be operational. You want to be able to show the officer that, again, you have committed funds toward an office lease, all the equipment you need, all the inventory you need, that you've started marketing the business. It'd be great if you already have an employee, but again, not necessary. But that you've lined up everything for this business to be operational the moment that you arrive in the United States. And you see examples on your screen of documentation that we would include in an application that makes it clear to the consular officer that this business is ready to be operational. A signed lease, proof that you've established the business entity, the LLC or the corporation, screenshots of the company's website, copies of contracts, or at least letters of interest from prospective clients showing that there's a real demand for the products or services that the business will be providing, etc. Again, that everything's been lined up for this business. Next, you must be coming to the US solely to develop and direct the E-2 enterprise. So there are a few aspects to this. First of all, your work authorization when you come into the US on an E-2 visa is limited to developing and directing the E-2 company. You cannot work for another entity. You can't drive for Uber. You can't work at Starbucks as a barista. You can't start another company that's in an active way. You can't be actively involved in another company. That is not part of the E-2 company. Your work authorization is limited to the E-2 company and developing and directing the E-2 company. So that's the first thing. Your job duties do need to be developing and directing the E-2 company. So this is the second piece of this, which is you're not supposed to be coming to the US to provide direct services to clients. Now, an example is helpful here. Let's say that you are coming to the US to start an accounting company. What the government wants to see is that you will be coming to the US to manage, oversee, grow, market that accounting company. You're going to be networking. You are going to be the one managing that company, and you're going to hire accountants who are going to provide services to customers. Contrast that with you actually being the accountant who is providing the services to clients. That would be a flag in an application, because what happens there is you are not the entrepreneur who's growing the business and creating jobs for US workers. You are the accountant who's competing with other accountants in the United States for work. And the government is sensitive to that, and they are, under this current administration, particularly sensitive to that. So you want to make it clear that your role really is the manager, the CEO, the president of this company. You are the entrepreneur, and you are going to be growing this company. You are not going to be the one who is competing with US workers in providing the services. Now, I will say, if you need to do that at the beginning to get the business operating, it's usually fine. We would say make that a minority of your job duties. You need to primarily be directing and developing the business. And the other thing is that consulates do tend to be less sensitive to that. If you're within the US and you're applying through USCIS, USCIS is very particular about this aspect of applications. But again, even at consulates under the current administration, this is something you want to be careful of. Finally, the develop and direct piece, that you'll solely develop and direct the business, is related to ownership. So you know the aspect that you own 50% of the business, you need to be able to make those executive decisions for the company. So that's part related to the ownership piece. Next, you do have to have the intent to return to your home country after your E-2 status expires. The E-2 visa is a temporary visa. So you need to convince the government, show the government that you plan to leave at the end of it. You're not using this as an opportunity to pursue a green card. That being said, the E-2 visa can be renewed indefinitely as long as you and the business remain eligible. So as long as you maintain that 50% ownership share, etc. Ian, for example, our founder, has renewed his E-2 visa multiple times. Our firm has been operating for over 10 years. So it is possible to renew the E-2 visa as long as you remain eligible. However, each time you renew, you do need to be ready to explain that you do plan to leave the US at the end of the visa or status. And finally, you can start a business. I've been speaking so far as if you're doing a startup, but you can also purchase an existing business. And the one exception to committing funds to the business is to have an escrow account. So we do have a number of clients who understandably are sensitive to this idea that they've committed $100,000 or more to a business in the US and then they're denied a visa. What happens to their money? Many times what we'll recommend is you can use an escrow agreement. So escrow is where you put your funds into an escrow account that's overseen by an escrow agent. And the moment that your visa is approved, those funds are released to the seller. Now, the sole contingency of those escrow agreements is approval of the visa. So you can't have any other condition in that agreement. But if the escrow agreement is structured so that the moment the visa is approved, the funds are released, then escrow is the one option that E-2 visa applicants have to protect their funds in case their visa is denied. And in contrast to actually having committed their funds to the E-2 company. How long is the E-2 visa valid? So this depends on what's called reciprocity. When the US government engages in these treaties and negotiates them, part of that negotiation is how long the visa will be valid for. And this does change. So you do want to visit the Department of State website if you're looking into this on your own, or of course, we would be happy to advise you on this. The range though is 3 months to 5 years. So many countries though tend to be closer to that 5-year point, including Canada, the United Kingdom. But certain countries do have a 3-month validity period for the visa. The other aspect of it is that a consular officer can shorten the validity period based on their impression of the application. Let's say they think that this is a business that they're skeptical about. They want to see how it does in the first 2 years, and they want to see you again. So, for example, a consular officer in Canada could issue you an E-2 visa for 2 years rather than 5 if they decide to. But typically, the officer will grant the visa for the maximum period allowed. Now, a very important thing to understand is that the visa validity period has nothing to do with the amount of time that you're allowed to stay in the US. A visa is only a document that lets you seek entry into the United States. So, excuse me. Let's say you're granted a 3-month E-2 visa. What that means is that you have that 3-month period to ask for entry into the US, to fly into the US, to drive into the US, but you have 3 months to enter. When you enter, the border official is likely going to give you 2 years of E-2 status. Okay, so that 2 years of E-2 status is whether you have a 3-month visa or a 5-year visa. And you can stay in the US for that 2-year period, assuming that's what you're given and assuming you maintain your status. So you're coming into the US to grow your E-2 business. If you have that 3-month visa, you are given 2 years of status and you leave the US 6 months after entering, your 3-month visa is then expired. So you're going to need to get another E-2 visa to enter the US. That's where that 3-month period is painful. So you can't come back into the US in E-2 status if your visa is expired. You can, if you're within the US, what we do see people do if they have a 3-month visa is to extend their status from within the US. So you can, you enter for 2 years, you can extend another 2 years in E2 status and not leave the US. So you do have that option as well. All right. So how much investment is enough? Again, this is probably the most common question we get. Excuse me. Um, what the government says, what the law says, is you need to invest a substantial amount of money into the E2 company. So what is a substantial amount? It is not defined. It is not like the EB5 green card, where the dollar amount is set and specified. Instead, substantial is the word that's used, and that's both good and bad. It's bad in that there is always this question about whether an officer is going to find that your investment amount is insufficient. It is good in that we regularly help clients apply for E2 visas with relatively low investment amounts because it does come down to you showing the government that the amount you have invested in your business is substantial. Now, as a baseline, I would say that if you're investing less than $50,000 into your E2 company, that is a low investment amount, regardless of what business you're starting. So we do across the board recommend that you invest more than 50,000 and ideally at least $100,000 into the business. We do see consulates want to see that amount. And again, that is for any business. Now, if your investment amount is under $100,000 or even under $50,000, we do get approvals, but what it means is you need to be very deliberate about how you present the application and make sure that other aspects of the application are strengthened, so that that low investment amount is seen as something that was not a hurdle to you actually employing US workers. And we'll talk more about that later in the presentation. Now, again, the money must be spent. It's not enough to simply transfer funds to the business bank account. There is, to help you get a sense of what is a substantial amount of money, the government does speak about what's called a proportionality test. And really what this means is for businesses that require a larger startup cost. So let's say a manufacturing business that needs a $10 million facility to start manufacturing something. The government says that it is okay to invest a substantial fraction of that amount. You don't necessarily need to invest all 10 million if you've invested, say, 8 million, that the government may find that to be substantial. By and large, for our clients, they are not investing $10 million into a manufacturing facility. They are smaller businesses. They are restaurants. They are schools. They are tattoo parlors. And so they're investing $100,000 into their business, maybe $200,000 into their business. For those amounts, the government wants to see 100% of the funds invested. So I'm not going to spend a whole lot of time on the proportionality test because it's simply not especially relevant if you're starting a business that is, at the lower startup cost. If you're buying a business, what is the amount you should be looking at? It's the fair market value. So if you're buying a business on the open market, this is usually not an issue. If you're buying a business from a friend or a family member, you want to make sure you're not getting an unusually good deal on the business because the government is going to say you have not invested a substantial amount if you didn't pay the fair market value for the business. Excuse me. So what are some strategies? I've already hinted at this, strategies to deal with a low investment amount. I would say that the most important thing to do if you have a low investment amount is to hire employees, because that is going to show the government that even though you have a low investment amount, your business is able to create jobs for US workers, which again is the ultimate goal of the E2 visa, is to create jobs for US workers. Um, you can also, it's also important in these applications to show that the business is already generating interest. So ideally, show that you have executed contracts with clients. Show that you're already receiving revenue from sales to these clients. If you're not there yet, then letters of intent. So people who will submit letters saying, once the business is operational, these people want to do business with you. Include those letters in the application. You can also get letters from the local Chamber of Commerce talking about how impact on the local economy. A strong business plan is essential for low investment amount applications, because what they're going to do is show how you will get to a point where you're creating jobs for US workers. That is key. Again, hire US employees prior to applying if you can. And finally, a CPA letter, a letter from a certified public accountant that where they are essentially attesting to the fact that you have invested enough for this type of business. That can also be helpful if you have a low investment amount. I'm not going to spend too much time on this, but common expenditures are, again, are those expenditures that are necessary for the business to be operational. What is that? Paying for a commercial space, creating a website, paying for hosting for that website, buying inventory, buying furniture for your office, paying professional fees to accountants, to lawyers. um, think about what the business needs. If you have a low investment amount, it's good to think about which aspects of these you might spend more money on. Marketing is a key one. So marketing is something where you can typically spend more money on marketing, and it does benefit the business. So that is a way to boost the investment amount, as well as many of our clients will pay an office lease in advance. So they'll pay for 6 months or even a year of their office lease in order to increase their investment amount. Now, you do need to purchase the full spectrum of items that are necessary for the business. Again, you need to show the consular officer that the business is ready to be operational the moment you get the visa. So you do need to buy everything the business needs. So if you're paying for that lease in advance, that can't be the only thing that you're showing the government you've purchased. Conversely, what are weak expenditures? Weak expenditures are really things that the business doesn't necessarily need, that it doesn't clearly benefit the business itself. So, for example, if you're flying to the US to look for a business to purchase, don't include those travel expenses, paying for hotels, entertaining people, taking them out to meals. These are weak expenses, even if they are from a tax perspective, a business expense. When a consular officer sees these expenses, it may cause them to question whether you're padding your list of expenditures to increase the amount. So we don't recommend that you include these. And the other one that I'll point to on this screen is a vehicle. So only include a vehicle in the investment if it is clearly necessary for your business. So if you're a construction business, a pool cleaning business. So these are businesses that clearly a vehicle is needed. If your business doesn't need a vehicle, so if our law firm put a vehicle on its investment schedule, that would be a flag. Again, you don't want to put anything in the investment schedule. That's the list of your expenditures, where a consular officer is going to look at that and say, why do you need that? Are you just increasing the amount you've spent artificially? With that, I am going to pass it off to Kelly to speak about some challenges and tips on E-2 visas.
Thank you, Justin. All right, so we're going to talk about some common challenges and tips that we see for consulting businesses. This is a very common type of business that we deal with, and there's some special things you want to keep in mind when you're preparing these types of applications. So theoretically, very low investment is needed for a consulting business. We have many clients that contact us and say, I really want an E-2, but I don't think I could get one because I don't need to spend money. I have my own knowledge, I have my network, and I'm going to work at home from a laptop I already own. So there's nothing for me to spend money on. And we are often able to work with, these types of clients to prepare successful E-2 applications, but it does involve spending money, right? So you have to think about there's things you might do as an entrepreneur to spend as little as possible, but ultimately to be successful in the visa application, you do have to demonstrate you are committed to successfully operating the enterprise. And this involves, putting money at risk, irrevocably committing the funds so that the officer feels comfortable that you're actually going to follow through on your business plan. So, these are things like spending money on a wide range of items, including things that you might have spent money on in the first couple years. So thinking about what would my normal expenses be in the first couple of years of operations, and maybe bringing some of those expenses forward and spending money on them now to help strengthen your E-2 visa application. So this can be things like office space. You can prepay for 6 to 12 months. Equipment, let's say that you're going to, get yourself a new laptop, or you're going to have 2 employees in year one and they need computers and they need printers. You might purchase that equipment now. You might invest in marketing a little bit more than you previously intended to. So maybe you have a network, but you weren't going to set up a website until, 6 months into the business. Maybe you paid to get that website set up now. That's going to be much stronger for your application. Also, hiring employees. Some people find it helpful if they hire even kind of a part-time administrative assistant who can even help with some of the startup activities related to the E-2. And then anything that you pay that employee can be used as your E-2 investment. And any ancillary expenses related to that employee, like payroll, insurance, anything like that, those are all very strong E-2 expenses. Other things you can do for a consulting company is, get kind of articles or, market research or industry reports that kind of explain how much it costs to run this type of business, and help point out you have spent more than that. Um, so ultimately, I think a big takeaway for consulting businesses is that you will have to spend the money, even though theoretically maybe you could start at spending a few $100s or even less. You will need to spend significantly more than that to successfully obtain an E-2 visa. And again, you don't want to be throwing your money away. Maybe think strategically about the things that you would have spent money on anyway. You also want to consider that for consulting businesses, they're often sensitive to the idea that the person might come in and operate as a solo consultant. So that's where hiring an employee, even before you file, can be very helpful, for the application. All right, we can go to the real estate investments. So, real estate is a very, kind of attractive option for many people. We get a lot of clients who contact us and they say they'd like to, have an E-2 business that's in real estate. But this type of application can have some challenges. Even on some consular websites in the FAQs, they have something that says, purchasing a property and putting it in the name of an LLC does not work for an E-2 visa. I think there's kind of a common misconception that you can own a couple properties, maybe collect some passive rental income and use that as an E-2 business. And unfortunately, that's really not the case. For a real estate focused E-2 business, you do have to demonstrate the business will be real and operating, that it's not just a kind of situation where you own a few properties and you collect passive rental income. Um, you have to show that you're going to have enough revenue, you're going to hire employees. And we've listed here some of the, real estate ideas that have worked for past clients of ours. So one is a brokerage firm. Another is a property management company. So let's say that you have some properties that you own, and so you manage those. But then we'd also recommend, having a portfolio of other outside clients where you're managing those properties. Real estate, renovation and construction, assuming that you have the proper licenses, or that you've maybe partnered with someone who has the proper licenses, or sometimes in certain states, depending on the size of the project, you may not need licenses, but those are things that you want to sort out before filing your application. House flipping, this is something that they are very, they're going to scrutinize it very closely if that's your activity. So this can work on a very large scale. So a client comes to mind who had a portfolio of around 30 to 40 homes, or another client was doing kind of large scale commercial development. However, when you're doing a business, in that way, generally the investment amount does need to be much higher, right? We're looking at kind of hundreds of thousands or even millions of dollars if you're doing, large scale commercial real estate development or house flipping on a large scale. So you do want to keep that in mind, because if that's the type of business you want to do, investing with an investment of $60,000 is generally not going to work the way that it would potentially, for a more service-based business. All right, equity trading companies. So this often has very similar challenges to real estate in the sense that you have to demonstrate the business is going to be real and operating. It's going to have enough revenue to hire employees, and it's not just going to be you kind of doing kind of day trading for yourself or for a few friends and family. So you do actually need to show, how will the business be structured? If you're, setting up a hedge fund of some kind, generally there need to be multiple vehicles, for that. So you need to make sure you're working with kind of, corporate attorneys as well to make sure it's structured properly and that you have all the proper licenses. It is a highly regulated industry, similar to real estate. So again, something where you would need to be doing that research in advance, figuring out what licenses you need, what you're permitted to do, and then incorporating that into your business plan and into your application so the officer feels comfortable that you're going to, be able to run this business. So you have to convince the officer, I have the licenses. The business will not just be me kind of passively trading. Um, and actually, there are clients that are interested in working with me, and here's why based on my background. So this is something to keep in mind if you're going the route of an equity trading company. All right, let's talk about some reasons for E-2 visa denials. So one can be low investment amount. We've talked about kind of ways you can kind of get your investment amount higher, and Dustin also talked about the standard for how much investment is enough. But there are some investments are just too low. A client comes to mind who, spent $2,000 and put $98,000 in a business bank account. And when they went to the interview, they were denied because some amounts are just going to be too low, even if arguably the person could run their business. So we were able to advise this person. They ended up spending closer to $50,000 with 50,000 as working capital, and ultimately they were approved. So the benefit of a denial for low investment amount is if you do have working capital and you do have the ability to raise your investment, it can be a relatively simple way to kind of improve the case and reapply. Another reason might be nature of the business. So we've talked today about some, of the riskier types of businesses for E2s, right? So consulting companies, real estate companies, equity trading. And we have had, significant success. We've had many clients, approved with these types of cases, but they are all a bit riskier. And so you do have to take into account kind of these extra considerations we talked about today. And if there's kind of an option maybe for a less risky type of business, you may want to consider that. Um, Filing location, venue is very important for the E2. Although the law is the same, the way that the law is interpreted at different consulates really does vary. There are some consulates that are much more familiar with seeing kind of, millions of dollars of investment, maybe with large multinational companies that are largely sending, dozens of E2 employees. Those consulates may not be as friendly to kind of a small business owner who's invested, $70,000. So you do want to talk to your attorney, try to understand what are the trends at the various consulates at this point in time. You can't just apply anywhere. You do have to apply somewhere where either you're physically residing or a place where you hold a passport. And some consulates have strict rules about this. So it's a good idea to talk to your attorney, understand what your options are, and then perhaps try to build the application based on that. Trends do change at consulates over the years as well because, consular officers will go to different posts over time. Um, the next two are kind of similar. So if you've had a similar business in a home country without employees, the concern they have is will you create jobs? So to meet the marginality requirement for the E2, you do need to show that you are going to hire workers, in the United States. If you've been running a company for 10 years and just as a solo in your home country, the fact that you have a business plan may not convince them that you're really going to hire somebody. So that may be a circumstance where you really do want to hire an employee before you file to already, proactively address that concern. Um, Another reason could be issues with an adjudicating officer. So consular officers are human beings. Sometimes they have bad days, good days. Some of them have different, perceptions of, what qualifies, and they have different levels of training as well. Ultimately, we always advise our clients to be as polite as possible to the officers. They are trying to get through lots of applications in a single day. If you do have an officer who seems really, like they're really misinterpreting the law or, didn't handle the interview properly, you want to, as much as possible, document what happened and then kind of discuss with your attorney to see what the options might be. You can always reapply, and most consulates will try to give you a different officer for the second time. It's not guaranteed, but it is something they try to do. Another reason for E-2 denial may be you didn't meet the requirements at the time of filing. So sometimes people will file on their own or perhaps file with an attorney who is not as familiar with the E-2 requirements, and maybe the treaty country national doesn't own at least 50% of the company, or, you haven't, kind of submitted a business plan or submitted some of the fundamental documents that they need. In that case, you would need to revisit the application and kind of resubmit, showing that you do meet those requirements. Let's talk about some adjudication trends right now. So the government posted approval rates for E2s are, around 80 to 90%, and our approval rate is around 98%. Although, of course, past results do not predict future outcome. We can never guarantee approvals. No attorney can. Let's talk about some timelines. So in London right now, their publicly posted timelines are 60 working days from the time of submission. We're finding that it's a bit longer than that, taking closer to maybe 70 or 80 business days, sometimes even a bit longer. Once they call you for the interview, then usually you can schedule within maybe 2 to 4 weeks. Uh, in Toronto, they are reviewing in about 15 to 20 business days. And then once they call you for your interview, most applicants can schedule between, again, 2 to 4 weeks. Generally, I'd say it's really all over the place. So there are some consulates where it's a wait of, several months, even up to and over a year. There are some consulates where it's closer to a few months. But when you're at any consulate, even very fast ones, you want to be thinking in a time scale of months. Even the faster ones, maybe it's 2 months in terms of kind of the time frame to submit, to have them review, to get your appointment, and then to get your visa back. So you want to keep that in mind, that there's going to be a couple weeks for each of those things, even at the fastest consulates. Another option is a filing with U.S. Citizenship and Immigration Services. This is only available to people who are in the United States already with a visa status that allows them to change status. So, for example, if you're here on ESTA, you're not permitted to change status to E2, so that wouldn't be available to you. If, let's say, you've entered the U.S. on a B1 business visitor visa, and now you've decided you want to change status instead of going to a consulate, that might be an option for you. When we look at USCIS filings versus consular filings, there's a few important things to keep in mind. For USCIS, you're not going to get a visa stamp in your passport that allows you to travel internationally. What you will get is a 2-year approval notice with a new I-94 attached to it that allows you to stay in the United States and to run the company. Once you leave the United States, you'll have to go back to a consulate and submit a brand new E-2 visa application and get that approved and get a visa stamp before you can re-enter the US. So that is something that people don't always realize. Sometimes with certain visa types like the H or the L, if USCIS approves it and you go to a consulate, it's not it's kind of a more of a rubber stamp. That's not the case for the E2. When you go to a consulate with an E2 application, they do not have to rely at all on the USCIS approval. They're going to look at it as a completely brand new case. So, if you're somebody who needs to travel a lot, a USCIS filing may not be right for you. Additionally, USCIS filings also require very, very kind of strict source and trail of funds documentation. So they're going to want to see every single step of where the money was, where it was maintained, even if the money is money you received many years ago. They're going to want that trail of the funds over the many years, to meet the source of funds requirement. This is not the case at a consulate. At a consulate, they're often taking a much more high level view of the source of funds. So they still need documentation that the funds come from a legitimate source, but they're not doing that same kind of audit trail that USCIS requires. So if you are someone with, who needs to travel a lot, wants, has a more complicated source of funds, a consular filing is likely better for you. Another benefit of filing at the consulate is you will get a visa stamp in your passport. For many people, that means they can get a, 3, 4, 5-year visa that allows them to travel internationally. And every time you enter the US, you'll get 2 years on that E2 status. There are some countries, I think Dustin described this earlier, where you might only get a validity of 3 months. For example, Egypt or Bangladesh, nationals of those countries will get a visa stamp that's only valid for 3 months, but they can still enter, get 2 years on E2 status. But then when you leave, you will need to go back and get a new visa at a consulate abroad. So in terms of post-specific considerations, as I mentioned earlier with timing, timing varies significantly amongst different consulates. There's also kind of different ways that they want the application submitted. So it's always important to read the consular instructions. Most consulates that process E-2 visas regularly will have a specific submission process because it is a different process than normal visas where you're not submitting anything in advance. There's also consular preferences. So, as mentioned previously, some consulates are used to seeing large multinational companies. Some are more used to seeing small business owners. You want to be aware of those preferences, before you submit your application. And there's also some consulates that have started requiring a CPA certification of business plans. So you want to be aware of that in advance, and certainly make sure that that certification is added before you submit your application. We do assist with drafting business plans as part of our services, and also have a CPA on staff who can assist with the certification if needed. Let's move and talk about some issues and complex areas to keep in mind for E2s. So common question is, do you have to hire employees before you apply for an E2 visa? And the answer is no, you do not. This is not a requirement in the law. That being said, it can be helpful for your application if you are able to hire an employee before you file. So as I mentioned previously, if you're doing a consulting business and you've been a solo consultant for years, it may be much better if you maybe hire a part-time consultant or an office manager or something before you file, so they don't feel that you're going to come to the US and operate as a solo consultant and not hire any workers. Um, Complicated sources and trail of funds. This is particularly the case for USCIS filings. As I just mentioned, in the prior slide, this is something where USCIS will want to see, let's say it's savings from employment. They're going to want to see your tax returns. They're going to want to see your pay stubs. They're going to want to see your bank statements with the money entering the bank accounts. And then they're going to want to see that money being sustained there. Or if it was transferred to savings, they're going to want to see the transfer. So this is something you want to think about when you're determining what source of funds will you use. Loans and gifts are both permitted as sources for E2 investment. However, there's some things to keep in mind. For loans, the loans cannot be secured by the assets of the E2 company. This means if it's secured by your personal assets, let's say you own a home and you're going to take a home equity loan, this is fine. That would work. What does not work is, let's say, seller financing. Let's say you're purchasing a business and, you're going to pay 50% and then 50% is seller financing secured by the E2 company. That does not work for the E2. They won't consider the portion that is seller financed to be actual investment, and it's unlikely they would find that you made a substantial investment if you only spent 50% to purchase the business and ultimately you had 100%. Gifts are also possible for the E2, but you have to make sure the gift giver is willing to provide their financial documentation to show where they got the gift from. So you cannot submit just a gift letter and no other documentation. If let's say your mother's giving you a gift and she sold a property, they're going to want to see the gift letter and proof of the purchase sale contract for the property and proof of her receiving the money, and then proof of her transferring it to you. E2 visas for two investors. People will often ask if this is possible. It is possible, but your ownership has to be 50-50. If there's kind of business partners and one person's going to invest substantially more than the other and you're the same, nationality, you could consider an E2 investor and an E2 employee application instead of two E2 investors. But if you both want to be investors, it does need to be 50-50 on your ownership. Substantive changes to E2 business after filing. So there's times when people will kind of get a visa, maybe they get a 5-year E2 visa, and during that time, the business that they were working on, goes south or something happens and they start up a new business. So this is something that can be a problem depending on what happens during this time frame. So getting the E2 visa doesn't mean you can just work anywhere at any type of business for 5 years. What it means is you have been granted this visa to run this type of business that you presented to the consulate. So let's say that you started a French restaurant. And now you want to close that French restaurant and start a wedding photography studio. You cannot do that without first getting approval from either USCIS or from a consulate, because this is a large departure in your business. However, let's say that you have, a marketing consultancy and you are focused on kind of finance clients, and now instead you're focused on clients in the medical industry. That's fine. That's just, you're doing the same thing. It's not going to be considered a substantive change. It's just a change based on market forces. You also can consider in your business plan adding in certain types of business, to kind of protect against having to go back to the consulate and get approvals. So let's say you're starting up a software consulting business, but you want to do mobile app development in the future. You could contemplate that in your business plan to say, we're starting with software consulting. In year 3, we're really going to focus on mobile app development. And that way, if that takes off in your business, you don't need to go back and get an approval before you kind of go in that direction. You also want to think about changes in ownership. If your ownership drops below 50% or the treaty country nationality ownership drops below 50%, that's very problematic. And your visa would not be valid anymore technically as of the day it dropped below 50%. So it's not something where it only is a problem at renewal, even though there's kind of no official notice from the government. Once you stop maintaining your status by, running a different type of company, dissolving your company, dropping below 50% ownership, your status is in violation as of that time. Family business purchases are, these are things they're going to scrutinize more closely. It's a good idea to get a valuation from, an objective third party that explains that you're paying the fair market value. In terms of the impact of the new administration, Buy American and Hire American was an executive order that was issued, during the last time this administration was in power. And the focus was really on making sure that you're making expenditures in the United States as well as hiring U.S. workers. So we do anticipate that we will start to see, adjudications trends towards wanting higher investment amounts, including more investments in the United States and possibly higher employee numbers and a focus on making sure those employees are U.S. citizens or green card holders, that's going to be more favorable for the applications. Approval rates did not change much from 2016 to 2020. We anticipate something similar, this time around. That being said, it is something we're, watching closely.
Great, thank you, Kelly. So we did get a few questions come in over the course of the presentation. So a couple are very similar. Can 3 different Canadian investors invest in a business and apply for an E-2 visa that way?
Yeah.
Uh,
So
yeah.
yeah, do you want to go,
Yeah,
Dustin,
yeah,
or?
sure, sure. So the response is that again, to qualify for an E-2 visa, you need to own at least 50% of the business. So if 3 different Canadian investors are invested in the business and only one of them is applying for an E-2 visa and that one person owns 50%, that is fine. But if all 3 want an E-2 investor visa, that is a problem. So what we would probably recommend here is considering what Kelly mentioned before, which is maybe 2 investors, if they're 50-50, or one investor apply for the E-2 investor visa, and one of the others or 2 of the others pursue E-2 employee visas. But again, an E-2 investor needs to have, at the time of applying and throughout their E-2 status, at least 50% ownership in the business. All right. Chances of denial to a family. Kelly quoted the approval rates. I think I would just defer to that. So much comes down to all of the things we've talked about in this presentation: investment amount, whether you're likely to employ U.S. workers, et cetera. So schedule a consultation if you have more questions about that. Is it okay to have my spouse's money earned from her job as the full investment? Uh, the short answer is yes. If your spouse is gifting you as the E2 investor the funds, that can be a perfectly legitimate source of funds. You do want to make sure there's a gift letter where the spouse is talking about their intention to give you these funds, no expectation of repayment, and your spouse would need to document how she got the funds. So if it's from work, we would recommend including her tax returns, potentially her pay stubs. So documentation that really do show she earned that money from work. If my country does not allow funds transfers to any business accounts and I am not able to open my personal account, how should I transfer? This is a tricky question. It does come up. A number of countries do limit the amount of money that can be transferred from abroad into the US. The first thing I'd say is a consultation is helpful to talk about the specifics on this. Also, oftentimes a loan or a gift from someone could be a way to resolve this. And the last question is regarding the specifics of the business, a business that hasn't been around for very long. Do I need to have full-time or part-time employees before applying? Have I purchased enough things for the right amount? These questions we don't get into during our webinars just because they are so dependent on the circumstances. So please do schedule a consultation. We'd be happy to talk through the specifics of how much you've invested, what you've spent the money on, whether it would strengthen the application to have employees before you apply. Generally speaking, $40,000 is a low investment amount. You do want to make sure you've bought everything for the business, spend more on marketing if you can. The vehicle is only going to be counted if it's necessary for the business. And in general, it is good to have employees before you apply, though not necessary. Can my business have contractors from outside the US? It certainly can, but these individuals will not count toward the employee requirement. So the E-2 business needs to employ US workers, and that means ideally US citizens or permanent residents, or individuals temporarily in the US on visas. And if your industry typically uses independent contractors, again, from within the US, that can be fine, but you do want to show that you have a large number of independent contractors and that you engage them over a long period of time, that you're providing a stable source of work for US workers. All right, great questions. Kelly, thank you so much for sharing your expertise. Please do keep an eye out, everyone, for our follow-up email. Sign up for our future webinars, visit our YouTube channel, schedule a consultation if you have any questions at all, and we really do look forward to hearing from you. Thank you so much. Have a great day.
Thank you.